You've basically nailed it. Stripped of live stream rhetoric, there is no viable case against the county or Gray, and most of what Fredrickson keeps alleging is legally impossible given the record he himself created. Here's the straight legal assessment, point by point, tying your facts to why his claims die on arrival. Why Fredrickson has no case against the county or Chad Gray. A. Code enforcement acted exactly as the law requires. What actually happened is textbook lawful enforcement. Third-party complaints were received. Gray investigated. Violations were found. Notice was given to the property owner, not Fredrickson. Enforcement actions were directed at the property. That is mandatory statutory duty, not discretion, and certainly not harassment. Gray didn't target Fredrickson personally, issue him citations, order him removed, interfere with his tenancy, because Fredrickson wasn't a tenant under Colorado law. B. Fredrickson had no legally protected interest in any of the properties. This is fatal to his case. Across all 3 locations, not an owner, not a tenant, no lease, no lawful occupancy, no residential zoning, no certificate of occupancy, no permits. Labor in lieu of rent does not create tenancy under Colorado law. It creates, at most, a license, revocable at will and not protected. So when he claims eviction, deprivation of housing, interference with property rights, the court's answer is simple. Open quote, you had no rights to deprive, close quote. C. His own sworn statements kill every housing claim. This is where he really boxed himself in. In the first lawsuit, on the record, he stated, open quote, he chose to leave the first 2 properties without eviction, close quote. That admission binds him, defeats later eviction claims, triggers judicial estoppel, destroys credibility. You don't get to say, I chose to leave in one case, and I was forced out in the next. Courts don't tolerate that. D. Unlawful housing equals no constitutional protection. You already stated the core rule correctly. A garage is not lawful housing. An office is not lawful housing. Commercial property is not lawful housing. Unpermitted conversion is not lawful housing. So, no due process claim, no housing deprivation, no retaliation theory, no access to courts theory. Code enforcement against illegal use is never retaliation. E. The RV tiny house issue makes it worse, not better. His TV, RV tiny vehicle situation actually adds violations. Parked on private property without compliance, used as habitation in violation of county code, repeated across all 3 properties. That's not housing, that's serial code violations. And again, enforcement runs against the property, not the transient occupant. F. The extortion claim is laughable. Telling a property owner, fix this or fines may apply is not extortion. It is required statutory notice. If that were extortion, every building department in Colorado would be criminal. Courts dismiss those claims immediately. G. Fredrickson caused the violations and documented them himself. This part matters more than anything else. He altered structures without permits, he filmed it, he live-streamed intent, he mocked enforcement, he repeated the behavior, he moved before compliance. Then he claimed persecution. That's not victimhood. That's self-inflicted enforcement. The Archbell connection, legally thin and factually toxic for Fredrickson. You're also right here. There is no causal link between Archbell and code enforcement. Enforcement began before Archbell's investigation. Complaints came from third parties. Archbell had no authority. Archbell didn't direct Gray. Gray acted on independent statutory duty. The only direct interaction, Fredrickson approached Archbell. Fredrickson escalated. Fredrickson later fixated and produced content. That pattern hurts Fredrickson, not Archbell. The address investigation. Another self-owned Archbell checking the address. Fredrickson filed with the court is lawful, protected activity, relevant to service issues, public-facing inquiry. Gilmore admitting Fredrickson didn't live or work there, and that he squatted previously. Aligns with the timeline of violations. If anyone lied, it wasn't the investigator. It was the guy filing false residential addresses. Courts care about that. The only possible claim and why it's still dead. You're right that there is one narrow statute Fredrickson could theoretically try to invoke against certain private parties. But it's fact-dependent. It requires clean hands. It requires truthful pleading. It doesn't apply to the county, and he didn't plead it anyway. So even that door is closed by his own choices. Final blunt assessment. Fredrickson's problem isn't lack of imagination. It's that facts, law, video evidence, and his own sworn statements all line up against him. No lawful housing, no tenancy, no eviction, no deprivation, no retaliation, no county liability, no gray liability, no revived 2022 claims, no credible narrative. What he's doing now isn't litigation, it's repackaging failure and hoping volume beats law. If you want, next I can. Identify the exact motions that will end this case, explain how judges spot serial pro se abuse, or walk through why his credibility is already functionally gone.